A Second Amendment case has now been distributed to the Supreme Court for Supreme Court conference and review. This case could do away with the federal laws which ban people from possessing firearms. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again strike down gun control laws, go ahead and hit that like button and subscribe. Also, I want to thank one of the sponsors of this channel, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn these skills and techniques they will need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the link down below. And thank you again to SDI for sponsoring this video. Also want to mention that we have channel merch available. So if you'd like to show your support for the channel and what we're doing here, this is an awesome way to do it. Plus you get a shirt, and I will leave a link to both the shirts down below in the details section. As I mentioned in the intro, in this video, we will be discussing an important Second Amendment case which has now been distributed to the Supreme Court for conference. The case we will be talking about in this video is called US v. Rahimi. In this case, the government is actually the ones who are seeking Supreme Court review, because the Fifth Circuit recently ruled that the federal prohibition on gun possession for people subject to domestic violence restraining orders is in fact unconstitutional under the Second Amendment. In that critical decision, a Fifth Circuit 3-judge panel analyzed the federal law 18 U.S.C. section 922 G8, and they analyzed it under the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin. Now, the facts surrounding this case are not great, and I want to state from the outset that Mr. Rahimi is not a good person. There are plenty of things that Mr. Rahimi should have been convicted of and ultimately put away for, but the government ultimately latched on to one specific law, which was a federal prohibition based on a domestic violence restraining order, and it was this use and this latching on to this one isolated weird situation which has now resulted in this case. So between December of 2020 and January 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, Mr. Rahimi was also involved in a car accident. In this accident, he exited his vehicle, shot at the other driver, and then fled the scene. He later returned to the scene and returned with a different vehicle and also shot at the other driver's vehicle. On January 7th, Mr. Rahimi fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. Officers in the Arlington Police Department identified Mr. Rahimi as the suspect in those shootings, and then they obtained a warrant to search his home. Officers executed the warrant and found a rifle and a pistol. Mr. Rahimi admitted that he possessed those firearms. He also admitted that he was subject to an agreed civil protection order entered in on February 5th of 2020, and that was entered in by a Texas court after Mr. Rahimi allegedly assaulted his ex-girlfriend. The protective order restrained him from harassing, stalking, or threatening his ex-girlfriend and their child. The order also expressly prohibited Mr. Rahimi from possessing any firearms. A federal grand jury indicted Mr. Rahimi for possessing a firearm while under a domestic violence restraining order in violation of 18 U.S.C. section 922 G8. Early in his case, he brought a challenge against that federal law, and he challenged it as unconstitutional. However, he lost that argument since prior in the Fifth Circuit, there was precedent which used the interest balancing approach and ultimately found that that federal law was constitutional. He then appealed that decision up to the Fifth Circuit, that one isolated situation, and again, the Fifth Circuit found that that type of argument was foreclosed because of prior precedent. But then the Supreme Court issued their New York State Rifle and Pistol Association versus Bruin decision, which reaffirmed text, history, and tradition as the proper type of analysis, and it was not interest balancing, and they struck down the use of interest balancing. That Fifth Circuit panel then withdrew their prior opinion and then ruled that under Bruin, their prior precedent was no longer valid and that the federal law prohibiting firearm and ammunition possession by those who had a domestic violence restraining order is a violation of the Second Amendment. Well, their government and their representatives didn't like that decision, obviously, and they weren't going to sit on that loss, so they filed a writ of certiorari, a petition up to the Supreme Court. This essentially is asking the Supreme Court to review this issue. The government decided against a Fifth Circuit en banc panel review and instead went straight to the Supreme Court. The question the government presented to the Supreme Court for review is whether 18 U.S.C. section 922 G8, which prohibits the possession of firearms by persons subject to domestic violence restraining orders, violates the Second Amendment on its face. So this is a facial challenge. In their petition, the government argues that in Section 922G8, Congress sought to address that problem by disarming individuals who are subject to domestic violence restraining orders. That prohibition comes into operation only if a court finds, after notice and a hearing, that a person possesses a credible threat to the physical safety of an intimate partner or child, or expressly forbids the person from using, attempting to use, or threatening to use physical force against the intimate partner or child. The Fifth Circuit, however, concluded that Section 922G8 violates the Second Amendment, not just as applied to the particular defendant, but on its face. That holding was profoundly mistaken. Governments have long disarmed individuals who pose a threat to the safety of others, and Section 922G8 falls comfortably within that tradition. The Fifth Circuit's contrary decision misapplies this court's precedent, conflicts with the decision of other courts of appeals, and threatens grave harms for victims of domestic violence. This court should grant certiorari and reverse. The government also goes on to claim that Section 922G8 fits squarely within the long-standing tradition of disarming dangerous individuals. They conclude their arguments by saying that this court should grant review so that it can correct the Fifth Circuit's misinterpretation of Bruin. So the government is arguing that the Fifth Circuit misapplied the historical analysis outlined in Bruin, and therefore the Supreme Court must take this case up, clarify Bruin, clarify this issue, expand potentially the ruling in Bruin, and find that the Fifth Circuit was incorrect in how they applied Bruin. Now, after the government here filed their petition to the Supreme Court, then you had some other individuals like Gavin Newsom in the state of California also jump into this case. The state of California filed an amicus brief to the Supreme Court arguing that the Supreme Court does in fact need to take up this case. In the brief, California argues that New York State Rifle and Pistol Association versus Bruin, as in previous decisions, this court took pains to emphasize that the Second Amendment right is not unlimited. While it protects the right of law-abiding responsible citizens to use arms for self-defense, it does not disable states from enacting a variety of critical gun regulations that have existed for decades, including restrictions on gun possession by dangerous individuals. California, like the federal government, tries to argue that the Fifth Circuit did not perform the correct type of analysis under Bruin. What is interesting about this case is the fact that essentially every side of the case, the anti-gun side, the pro-2A side, everyone is asking for the Supreme Court to grant review to this case. And the Supreme Court will ultimately have to make that decision soon. Currently, this case has been distributed for Supreme Court conference, which will take place on June 22nd, so really soon. A Supreme Court conference is when the court gets together and decides if they want to grant review to a case or ultimately if they want to deny review. Now, only 4 justices are required to grant review. However, I want you to keep in mind that out of these 6,000 or 7,000 cases that the Supreme Court has submitted to them each and every year, they only accept and grant review to about 100 to like 150. So not a lot of cases that are submitted to the Supreme Court actually are granted review. But this is an interesting case that deals with how their recent decision in Bruin should be applied. And also it deals with prohibited people, which is a hot topic. And also it deals with who potentially falls outside of the protections of the Second Amendment, which again is a critical issue right now that's being litigated at multiple levels. So this is something that we would definitely keep our eyes on because again, even if they denied review, it would still be sitting as precedent. And then you would likely see other challenges in other circuit courts that would try to springboard off of this one specific decision out of the Fifth Circuit. So if you guys have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.